Hello, welcome back to Legal Brain. Today I'm going to discuss yet another important area, an exam point of view, and that is discharge of surety from liability. I'm going to discuss how surety's liability can be discharged, by different modes in exam point of view. So do listen to the class and try to understand. The first mode is by notice of revocation, which is mentioned under Section 130 of Indian Contract Act, 1872. And in this mode, it is stated that by virtue of Section 130, the surety can just send a notice to the creditor and to let him know that surety want to get discharged from his liability. And through this mode, he can just discharge all the liability that he is having. And it says that a continuing guarantee may at any time be revoked by the surety for regarding all the future transactions. So we have to note just one point. This is regarding the future transaction, not the past transaction. And for the past transaction, the surety will be held liable. And there is a case law for that, Oxford versus Davis. And in this case, the defendant had guaranteed the payment of bills to be discounted for Davis and Company for a period of 12 months. That means for future transactions, the upcoming 12 months, future transactions. And before the bill was discounted, he revoked the guarantee. And it was held that the defendant had the right to revoke the guarantee. So just like I have told you, this is regarding a future transaction, okay? And he just surety just tried to, revoke, cancel by, letting the creditor know about that. So this is the point, always the surety will be liable for the past transaction, not for the present transaction if he is revoking it. So this is the first mode. The second mode is regarding revocation of continuing guarantee by surety's death. So here, death is the subject matter. And it is said that by virtue of Section 131 of Indian Contract Act 1872, the death of the surety is a ground to discharge the surety's liability. So it is stated that if there is no contract to the contrary, then the surety's liability will get to an end if the surety died. So thus, if surety dies, the continuing guarantee regarding the future transaction will stand revoked. But if there is any contract to the contrary mentioning the liability part of the surety, then the surety will not be discharged from the liability. And for any valid revocation of continuing guarantee, the death of the surety must come to the notice of the creditor. So here, yet another important point is that the creditor should get to know that the surety had passed away, he had died. And there is again an important case law, that is HR Basivaraj versus Canara Bank 2010 case. And in this case, it was held that in the absence of a specific written document by the deceased surety revoking the guarantee cannot be revoked by the legal representative, and the legal representative will be liable to repay the loss. So this case, it is clearly stated that the legal representative will be liable if there is no contract to the contrary. So this is the second way of, it's like natural way of revocation, that is by death of surety. And the third point is by variance, and we just mentioned in the Section 133 of Indian Contract Act 1872. And variance means like, an alteration, a change, a modification. That is the meaning of variance. And it is stated that any variance, any alteration, any modification which is made in the contract, in the terms and conditions or clauses of the contract, without the surety's consent, if it is made between the principal debtor and the creditor, then automatically the surety's liability will get discharged off. And, in terms of the contract between the principal debtor and the creditor, discharges the surety as to the transaction subsequent to the variance. This is the third mode. The fourth mode is by release or discharge of principal debtor. So this is an important point mentioned under Section 134 of Indian Contract Act 1872. And it says that the surety is discharged by any contract between the creditor and the debtor by which the debtor, the principal debtor, is released, or by any act or omission of the creditor, the legal consequence of which is the discharge of principal debtor. That means whenever the principal debtor, the person who is liable to repay the money, is being discharged from the liability, then that second itself, the liability of the surety will also come to an end. So because we have already mentioned under Section 128, it's clearly mentioned under Section 128 that the liability of the surety is coextensive with that of the principal debtor, unless it is otherwise provided in the contract. So the meaning is that the surety will be only having the liability until the principal debtor is having the liability. The surety concept which works for the principal debtor. So once when the principal debtor is being released from the liability, then automatically the surety will also get released by virtue of section 134. And if the principal debtor is discharged, is also discharged from the liability, and section 134 provides two modes. The first one is that a contract between the creditor and principal debtor in which the principal debtor is discharged. Second one is by any act or by any omission of the creditor. It has a legal effect of discharging the principal debtor because of any act or any omission done by the creditor, and which is giving like a legal effect of discharging the principal debtor. Then that second itself, the liability of the surety will also get discharged. Then the fifth mode is by composition, extension of times and agreement not disuse. This is an important point. And by virtue of section 135, it is mentioned that a surety may also get discharged from the liability in case of three modes. The first mode is the creditor and the principal debtor contract for composition in return. That means, they're making a compromise. Then, they are like making a compromise and understanding between the principal debtor and creditor and says that, you don't need to make the payment. If then, the surety's liability will get discharged. The next point is the promise to give time to the principal debtor. Creditor is willing to give time, extension of time to make the payment. Then the liability will get, all of the surety will also get discharged. Next is the contract not to sue the principal debtor. And if the surety does not give his assent, his consent to any of these three modes, it will automatically discharge the surety's liability. And by virtue of section 135, the contract between the creditor and the principal debtor, by the creditor makes a composition, a change, a compromise, an extension of time, an agreement, whatever be that, if the surety doesn't give any consent, assent for it, the surety's liability will get discharged. And next is section 136, which says that surety not discharged when agreement made with third person to give time to the principal debtor. And it says that where a contract to give time to the principal debtor is made by the creditor with the third person and not with the principal debtor, the surety is not discharged from his liability. And again, there is an example C, the holder of an overdue bill of exchange drawn by A as a surety for B and accepted by B, contracts with M to give it to B. So A is not discharged here, and C, the holder of the overdue bill of exchange drawn by A as surety for B and accepts by B, contracts with M. So this is like example, it's in which speaks about section 136, the the liability of surety. And next is section 137, which it says that creditors' forbearance to sue does not discharge the surety's liability. Section 137. So a mere forbearance on the part of the creditor to sue the principal debtor or to enforce any other remedy against him or does not, in the absence of any provision in the guarantee, contrary to the contract, which discharges the surety. And the sixth mode is discharge of surety by creditors' act or omission, impairing surety's eventual remedy. So which is mentioned under section 139. And it says that if the creditor does any act which is inconsistent with the rights of the surety, or it omits to do any act which is duty to the surety requests him to do. So if there is a duty for him to do and he's not doing it, and the eventual remedy of the surety himself against the principal debtor, he thereby affected and the surety is discharged. So example, B contracts to build a ship for C for a given sum to be paid by installments as the work reaches certain stages, and A becomes surety to C for B's due performance of the contract, and C, without the knowledge of A, prepays to B and the last two installments. So A is discharged by his prepayment. Next is how far the surety will be having his liability. So this is mentioned under section 128 of Indian Contract Act, and it says that a surety's liability is coextensive with that of the principal debtor. And it says that unless the contract provides to the contrary, as soon as the principal debtor makes any default to the payment of the debt, the surety becomes liable. Thus, a creditor is not bound to proceed against the principal debtor first, and he can directly sue the surety if he wants without suing the principal debtor. However, until the principal debtor makes any default, the creditor cannot ask the surety, the creditor cannot ask the surety to pay the debt, and hence the surety liability is always secondary and just coextensive with that of the principal debtor. And so these are the different modes in which we can discharge surety's liability. So it's an important question. In an exam point of view, this is an essay question, and there are different modes and a variety of sections which speaks about how to discharge the surety's liability. I hope it's clear for you. If you have any doubt, do comment below. I'll be responding. Thank you for listening to me. Thank you.